the property provisions of the Family Law Act do not apply at this time to common law partners. I'll give you an example. If you and your common law partner purchase a home and it is only in one partner's name, and, for example, you didn't contribute financially. However, you are in the relationship for 7 or 8 years. And during that 7 or 8 years, you paid for the pool, you paid for the roof, you paid for the cabana, the driving. But then all of a sudden, you separate. And because the property provisions of the family law do not apply, that person could simply say, hey, the house is in my name. It's my house. You're not getting anything. But in fact, they are entitled to some property claims, but they would have to use equitable claims. So that's why you need to sit down with an experienced family law lawyer to help you in those situations, quantify your contribution. However, if you're married, you don't need to go through that exercise. A lot less evidence is required to figure out a married spouse's share of net family property than it is to figure out what a common law partner's share of property is. It may be a little painful or uncomfortable drafting the agreement, but I think it's great planning. If the agreement, whether it's a cohab agreement or a marriage contract, is drafted properly with full financial disclosure, independent legal advice, and reflects a fair resolution of the matter in the future, it could save a lot of conflict when the parties do separate. So the uncomfortableness at the beginning could lead to an easier road at the end of it.